All rise. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Our case today is Danny Ocean versus United States.
Please be seated. Ms. Zabkowitz.
Chief Justice, may it please the court. My name is Megan Zabkowitz, and along with my co-counsel, Ariane Strombaum, I represent the petitioner, Mr. Danny Ocean, in the matter before the court. Your Honor, at this time, petitioner would like to request to reserve 2 minutes for rebuttal. Thank you. This case is about the deprivation of one man's rights throughout the entire judicial process. I will be discussing the first issue, that the government's discrimination against religious jurors violates the Equal Protection Clause of the 14th Amendment, and my co-counsel will discuss the government's attempt to unfairly increase Mr. Ocean's prison sentence. The petitioner respectfully requests that this court reverse the United States Court of Appeals for the 14th Circuit and find that it is a violation of the Equal Protection Clause to discriminate against religious jurors for 2 reasons. First, based on precedents set by this court, peremptory strikes that are based on religious classifications are discriminatory and should be subject to a strict scrutiny analysis. Second, by permitting blatant discrimination of religious jurors, this court would be setting a precedent in direct opposition of public policy with regards to religious tolerance. Turning to my first point. Based on precedents set by this court in Batson versus Kentucky and subsequently JEB versus Alabama, it is a violation of the Equal Protection Clause to discriminate against jurors based on religious classifications.
It's been many years since those 2 cases. Why do you think that religion should be treated in the same way as race and gender?
Your Honor, both the Batson court and the JEB court said that the Equal Protection Clause guides the use of peremptory strikes. In Batson versus Kentucky, this court stated that it was under the guise of, or under the Equal Protection Clause that peremptory strikes should be exercised. And in JEB versus Alabama, this court said that there should be similar prohibitions on strikes based on any other classification receiving heightened or strict scrutiny analysis under the clause. Under equal protection jurisprudence, religion is afforded a strict scrutiny analysis, and any discrimination by the government on the basis of a juror's religion should be afforded a strict scrutiny analysis.
The rationale of JEB, however, had to do with the long history of invidious discrimination against women, for example, in that case, in extending the Batson race-based prohibition to sex-based peremptory strikes. And so it was a very historically based analysis. It wasn't just an application of traditional equal protection standards of review. And what is there about a religious-based peremptory strike that requires that same sort of treatment? Is there a history of this sort of thing in our country?
Yes, Your Honor, there is a history. One of the ways that the court addressed the discrimination of gender in the JEB court was when it stated that while the discrimination in the jury selection against genders was not a long history as it was against different races under Batson versus Kentucky, it did state that discrimination outside of the peremptory strike context against genders was long and was something that the court addressed within the peremptory strike context.
But why is it that we should look to discrimination in other spheres as opposed to just looking at whether particular groups have been discriminated against with respect to their role as jurors?
Your Honor, the reason that religion requires a strict scrutiny analysis and why we're looking at that as a different than other discrimination in other classes is because under the Equal Protection Clause, it is afforded a strict scrutiny analysis.
But do you concede, Ms. Zabkowitz, that there really is not a history of discrimination with respect to religious people serving on juries?
Your Honor, that might not be the case, a long history as long as the peremptory strike has been utilized. However, in the last decade, circuit courts and state courts and federal courts have seen an increase in this type of a challenge, and it is becoming something of a historical pattern of discrimination against religious jurors. So it is something that may not have been happening 50 years ago. It is something that the circuit courts are seeing right now, and this is why this case has made it this far, and this court needs to protect religious jurors from discrimination based on this classification of religion.
So you concede that there is not a history of excluding jurors on the basis of their faith?
Yes, Your Honor, there doesn't seem to be that. However, outside of the context of peremptory strikes, there is tremendous amount of religious discrimination in this country.
Why is that relevant here?
Well, that was the analysis that the JEB court undertook.
No, the JEB court analysis was very much focused on jury duty and the fact that women were excluded from serving on juries.
Yes, Your Honor, but in JEB versus Alabama, the court said that because the stereotypes against gender discrimination had wreaked so much havoc outside of the context of peremptory strikes, that active discrimination against litigants or against jurors on the basis of gender inside the context of peremptory strikes was something that it wanted to undertake and wanted to protect. So the JEB court did look and analyze, it did look into the context of peremptory strikes. It also analyzed the gender discrimination outside of peremptory strikes as well.
What's next, Ms. Zabkowitz? Is it age? Is it sexual orientation? Is it nationality? Is it class? I mean, there are lots of ways in which we are classified and divided in this country. Why should we treat this one as so special, especially given that you've conceded that there really isn't a historic pattern of juror discrimination with respect to this classification?
Your Honor, the Equal Protection Clause is what's guiding the use of peremptory strikes, and it will only go as far, the protection against peremptory strikes, against discrimination against jurors, will only go as far as the Equal Protection Clause. So any classes affording a strict or a heightened level of scrutiny under the clause will be the classes that are protected. Right now, race, nationality, race, national origin, and alienage are all protected. Gender is also protected, and now religion needs to be the next that's protected.
But we usually don't treat religious discrimination under the Equal Protection Clause. We really usually see it in a First Amendment context.
Yes, Your Honor. However, when a juror is discriminated against because of his or her membership in a protected class, that does fall under the Equal Protection Clause, and that is something that this court needs to consider. Again, it's based on the precedent of what this court has said, that the Equal Protection Clause does protect jurors from discrimination based on their membership of a protected class.
How do we know, in the typical case, what religion a person is a member of? Unlike race, unlike gender, it's not apparent. Do we now open voir dire to questions about a person's religion, their sincerity with respect to their religion?
No, Your Honor, we would not do that. This court would not do that. What would happen is that any strike that's based on a religious classification of any kind, beliefs or affiliation, would be subject to a strict scrutiny analysis, and the strike would need to be narrowly tailored to serve the government's compelling interest. Your Honor brings up a good point in that one of the problems here is that the lower courts and the circuit courts have tried to distinguish among classifications of religion, whether it's beliefs, practices, affiliations, and the circuit courts have not been able to determine a test that would be appropriate to draw the line down religion. That's why this court needs to adopt the strict scrutiny analysis for strikes based on religious classifications.
Do you think we should do the same thing for political beliefs?
No, Your Honor, just for religious beliefs or any other beliefs afforded a strict or heightened scrutiny analysis.
Well, political beliefs are afforded the same kind of treatment under the First Amendment as religious beliefs are.
Yes, Your Honor, under the First Amendment, but again, under the Equal Protection Clause, this court should just, this isn't asking the court to do anything new.
It just seems funny to me, because usually the way we treat religious discrimination is through First Amendment analysis. Now, I'm suggesting that we similarly treat discrimination on the basis of political beliefs. You have this viewpoint, so we're going to treat you in a way that's worse than somebody who has another viewpoint. Also under the First Amendment, they seem pretty comparable to me in terms of the way the court treats it. So why shouldn't they be comparable here? And then that would make a very different thing of peremptory challenges, where we sort of said, peremptory challenges, which historically have been used as a way to ferret out people with beliefs that maybe are not appropriate, or at least not appropriate for our client, all of a sudden start being subjected.
Your Honor, the purpose of the peremptory strike is not served when a juror is struck based on a stereotypical assumption about their ability to serve, just because he or she may go to church on the weekend once in a while. In fact, here, the jurors demonstrated that they are engaged in a litany of other activities, and yet the government imputed its own beliefs onto the jurors and stated that because these jurors go to church every once in a while or play the organ at church, they would not be able to sit and be impartial.
The reason why those kinds of that kind of stereotyping in the use of peremptory strikes is forbidden in the case of race and sex is because the stereotype is invidious. It doesn't hold up. But in striking a juror peremptorily based on firmly held religious beliefs that might preclude that juror from rendering a judgment is based on the kinds of assumptions that are perfectly valid in the context of firmly held religious beliefs. Some religions prohibit their adherents from sitting in judgment over other people. Why shouldn't that be a legitimate basis for the exercise of a peremptory strike?
Your Honor, that is far too broad of a classification or of a grouping to say that because you go to church, you definitely have a specific belief and you would be unable to sit in judgment of another person.
Well, maybe not definitely, but certainly there are some religions that you would say, the odds are pretty good that this is actually going to affect the way they serve as a juror.
Your Honor, the problem with the idea of just striking jurors on the basis of a belief is that, again, it's the government imputing its own beliefs. It's deciding that this juror believes something because I think that's what the juror believes.
Well, then that same rationale would apply to strikes exercised against potential jurors because of their political beliefs, to go back to the hypothetical that was advanced earlier. Mm-hmm. The prosecution might prefer all Republicans, right, on the jury because they're more law and order than Democrats, right? So is that going to be the next category for Batson?
No, Your Honor. Again, under the Equal Protection Clause, the classes that are afforded a strict scrutiny analysis or a heightened scrutiny analysis are the only classes that need to be protected.
Content-based restrictions on speech get strict scrutiny under the First Amendment, and that sort of political stereotyping would constitute a content-based
yes, Your Honor.
restriction, right?
The line here, though, is under the Equal Protection Clause. That is as far as the line should be drawn.
What cases are you referring to that give strict scrutiny specifically under the Equal Protection Clause to religion?
No cases give strict scrutiny analysis under the Equal Protection Clause, Your Honor, but both Batson and JEB have stated that any classes that are protected by a strict scrutiny analysis under the Equal Protection Clause should be afforded that same protection.
No, but that's what I'm asking. What cases are you referring to that said that specifically under the Equal Protection Clause, religious discrimination receives strict scrutiny as opposed to under the First Amendment?
Your Honor, there are no cases that state that. What this...
Yes, so that's what I was suggesting. In that sense, religion and political beliefs are very much of a piece, that they do receive strict scrutiny, but under the First Amendment.
Yes, Your Honor. The problem here, though, is that if religion is not afforded a strict scrutiny analysis and something like a belief-based challenge is going to be a viable option or going to be the line, there will be an inextricable intertwining of the government with religion, and the government and the state will have to define what's a religious belief or what's religious enough for the purpose of peremptory strikes. And this is the concern that that the equal protection will then not be afforded to religious-based classifications.
What's your best lower court case?
The best lower court case would be United States versus Brown, in which the court said that out of the Second Circuit, that states that strikes based on religious affiliation or beliefs would not be valid or proper. The core equal protection principles guarantee that the government will not discriminate on account of religion would be meaningless if this court approves an exclusion of jurors on the basis of such assumptions and stereotypes arising simply because a juror is religious. Accordingly, Your Honors, this court should reverse the decision of the 14th Circuit and hold that peremptory strikes that target religious jurors are discriminatory and violate the Equal Protection Clause of the 14th Amendment.
Before you sit down, the case that you just cited, United States versus
Yes.
Brown, Second Circuit,
Yes.
actually held that Batson extends to religious-based peremptories and invalidated a jury verdict?
Activism, Your Honor. It struck it on activism. However, it stated that beliefs and affiliation were not proper uses of the strike.
I'm sorry, I'm not getting the distinction.
Your Honor, that's exactly, I see my time is up. May I have leave to answer your question?
You do.
Thank you. This is the exact problem with the lower court's decision, is there is no ability to make a distinction between affiliations and beliefs and activism. And this court needs to protect all religious jurors using this under the strict scrutiny analysis. Thank you.
Ms. Strombaum.
Chief Justice, may it please the court. My name is Ariane Strombaum, and I also represent the petitioner, Mr. Danny Ocean. As my co-counsel stated, I will address the second issue, that Mr. Ocean's prior conviction for simple drug possession does not enhance his sentence under federal illegal reentry statute section 1326. The petitioner respectfully requests that this court reverse the 14th Circuit's holding and find that when a state drug crime statute does not include an explicit element of intent, that state statute, conviction under that state statute, cannot serve to elevate a defendant's sentence under federal illegal reentry statute, section 1326. In this particular case, Mr. Ocean was convicted of simple possession, which is not a drug trafficking offense under the federal sentencing guidelines. And this court should reverse the 14th Circuit for three reasons.
Ms. Strombaum, when we look at the statutory section under which your client was sentenced, and that's 55H2B, do you agree that 55H2B indicates a presumed intent?
Your Honor, looking into the text of section H2B may imply an intent. However, the strict language of that section does not include an element of intent. Further, Mr. Ocean was convicted.
But you agree that when the legislature drafted that provision, in the context of the other provisions, H2A, that H2B is supposed to be a more severe offense than H2A. H2A has an intent element. That H2B essentially infers intent from possession of a substantial category, a substantial amount of drugs. You would agree with that?
Well, Your Honor, it is the contention of the petitioner that intent is not, in fact, implied in that section, because that goes against the the legislative history of the state of Packerland. Additionally, assuming an element of intent in that section.
Well, could you explain that to me? Why do you not see implied intent in that section?
Your Honor, the legislative history is used when a statute is ambiguous, and in this case, if this court were to determine that the statute is ambiguous as far as the implication is concerned, the legislative history states that there was a conflict as to the purpose of the statute. It was a difference between the statute targeting drug dealers and the statute targeting drug users, and that conflict was never resolved when this bill was passed. Therefore, implying an element of intent in that section would be improper. Additionally, any ambiguity in this statute should be construed in favor of the petitioner based on the rule of lenity. This court is considering two separate offenses.
Just on the lenity point, when was the last time that we held that a statute was so ambiguous as to avail ourselves of the rule of lenity?
Well, Your Honor, the Second Circuit held in the United States.
But this is the Supreme Court. When was the last time the Supreme Court did it?
Your Honor, the petitioner will submit a supplemental brief on that note.
It was a long time ago, as far as I can remember.
Yes, Your Honor.
We usually try to figure out what a statute means and what a statute says, and we don't easily, say, oh, well, we'll just go to the rule of lenity.
Yes, Your Honor. However, the plain language of the statute does not include an element of intent. Further, it's worth noting that Mr. Ocean was convicted under Section A2, which is not within Section H. A2 applies to simple possession. Jury...
Maybe you can help me with that. I'm having a real hard time with this statute, with all respect to the Packerland State Legislature.
Yes, Your Honor.
This is the strangest statute I have ever seen. And that alone is going to make me go to the rule of lenity pretty quickly. The actual base offense here is in subsection A.
Yes, Your Honor.
And it can either be simple possession or possession with intent to distribute.
That's correct.
The simple possession offense is A2, and that's what your client was convicted of.
Yes, Your Honor.
So what is subsection H exactly?
Subsection H applies to drug trafficking crimes.
But is that a separate offense? Is it a penalty enhancer? What is it?
Your Honor, Section H does apply to possession and possession with intent to distribute. However, according to the 2nd, 4th, 5th, 6th, 9th, and 10th circuits, if intent...
They didn't have this statute.
I'm sorry,
So
Your Honor.
I'm just asking you what this statute means.
Yes, so Section H that governs drug trafficking crimes does apply to Section A1 and 2, possession and possession with intent to distribute.
No, it says notwithstanding anything else in this law, here's how these people are sentenced.
That's correct, Your Honor.
Which suggests to me that it's a penalty enhancer and doesn't have any relevance to the application of the sentencing guideline here.
Your Honor, this section does apply. Essentially, we're considering whether the elements...
That was a lifeline, counsel.
Whether the elements in this Section H match up with those in the federal sentencing guidelines. And in this case, they do not, because intent is not included in the state statute.
Isn't this sentencing, or isn't this offense essentially the same, well, the Packer line statute, essentially the same structure as the structure that the 11th Circuit dealt with in Madera?
In fact, Your Honor, to the contrary, it is very different from the statute in the United States versus Madera. In that case, the Georgia statute that was used has a three-tiered structure where those three tiers are very different than the ones here. In the Packerland statute, drug trafficking is in fact a lower offense than simple possession or possession with intent to distribute based on the class levels for sentencing. In the Georgia statute used in Madera, drug trafficking was in fact a higher sentence. Additionally, in that case, the defendant pled guilty, and the jury was not provided with the opportunity to come to an independent determination of the facts in that case. In this case, the jury determined that Mr. Ocean, in fact, did not possess the intent to distribute cocaine, and therefore any elevation of his sentence under this statute would amount to a deprivation of his rights.
Your client was found guilty of possession of 88 grams of cocaine?
That is the situation in the United States versus Madera. It was 87 grams of methamphetamine. In this case, it's 100 grams of cocaine.
100 grams of cocaine.
Yes.
And no one argues that that's a personal use amount.
Your Honor, well, in fact, the jury determined that that amount was for personal use. To quote page 15 of the record, the jury instructions state that the jury should only find the defendant guilty of possession with intent to distribute if it believes beyond a reasonable doubt that Mr. Ocean had the intent to manufacture, sell, or deliver cocaine, and the jury declined to find that he did possess that intent.
Nevertheless, under the Packerland statutory scheme, isn't possession of 100 grams of cocaine defined as drug trafficking under their statute?
It is, Your Honor. However, that section, H2B, does not include an element of intent. And therefore, because of that reason, and because the jury found that Mr. Ocean did not have intent to distribute, Mr. Ocean's sentence cannot be...
Suppose he had 40 grams instead of 100 grams, and he was sentenced instead under H2A. What would be the result then?
Your Honor, to clarify your question, if Mr. Ocean was found to have the intent to distribute?
No. So he had 40 grams, and so he was sentenced under H2A, which applies to between 25 and 50 grams.
Yes, Your Honor.
Is that right? So under H2A, he would have gotten the greater enhancement.
Well, theoretically, Your Honor, that is correct. However, Mr. Ocean was found not to have the intent to distribute. So that section would still not apply in this circumstance, even if Mr. Ocean had a lesser amount of the drug in his possession.
So it's impossible for someone to be convicted under sub A2, the simple possession offense, and be sentenced under HA?
Yes, Your Honor, if the jury determines that the defendant did not have intent.
Well,
Yes.
HA requires intent to distribute.
That's correct, Your Honor.
And so it would be an inconsistent verdict.
That is correct,
The
Your Honor.
jury doesn't decide the H, A, or B question, right?
The jury does consider, in this case, they did consider the amount and the type of the drug that was within Mr. Ocean's possession. And even with that information, they declined to find that he had the intent to distribute.
I mean, you see why this is so bizarre, right? If you think about H2A and B, it's clear that B is supposed to be for people who have greater amounts of the drug and than A, and that B is supposed to be the more serious than A. And yet what you're suggesting is that we should adopt an interpretation of H2A and B such that A would receive the greater sentence enhancement for the lesser crime, and B would receive the lesser sentence enhancement for the greater crime.
Well, in fact, Your Honor, what the petitioner is suggesting is that any ambiguity in the statute, which this court has highlighted, should not go to enhance Mr. Ocean's sentence. That ambiguity would force Mr. Ocean to serve 4 more years in federal prison than what he is due to serve fairly under the law.
Well, I guess I just pointed out an anomaly and an oddity in your way of reading the statute, which might suggest we should just read the statute differently, not throw our hands up in the air and say, okay, we can't figure it out, you win.
Yes, Your Honor. However, given this court's this court's holding in the United States Taylor versus the United States, where a court is to look to the jury instructions and the indictment and other materials used in the course of the trial.
In what sense do we have a Taylor problem here?
Because, Your Honor, the matter of conviction is at issue for the purposes of federal sentence elevation.
Right, but all Taylor says is that we don't look at what the defendant did. We look at the definition of the crime under state law to determine whether it's either a career offender predicate or an armed career criminal act predicate or a predicate under this kind of a recidivist guideline that we have at issue in this case. And you know, we may look to other sources like a charging document, et cetera, if there's some confusion about what the defendant was actually convicted of, but we just don't have any of those issues here. The statute tells us what the nature of the crime is, defines the crime, and the fact that it's confusing doesn't create a Taylor problem that sends us scurrying to the jury instructions.
Well, Your Honor, the petitioner is using Taylor to explain the use of the jury instructions to further clarify Mr. Ocean's conviction and the fact that intent was not included. Further, additional reasons why this court should reverse the 14th Circuit.
Do the jury instructions have the force of law?
I'm sorry, Your Honor?
Jury instructions don't have the force of law. They don't supplement the definition of this crime in the statute.
That's correct, Your Honor. However, under the modified categorical approach that this court said applied to drug trafficking crimes, the jury instruction and the indictment can be used to clarify the conviction.
The modified categorical approach is only necessary if there's some confusion about what the defendant was convicted of.
Yes, Your Honor.
Not what the definition of the crime is. Do we have that sort of confusion here, or do we know what he was convicted of?
Well, Your Honor, Mr. Ocean was convicted of simple possession.
Okay.
Which
so we don't have a Taylor problem here.
That's correct, Your Honor.
Wasn't he convicted of drug trafficking?
No, Your Honor. He was not convicted of drug trafficking. He was only convicted of simple possession, and that's why his sentence should not be elevated in this case.
And then sentenced under the drug trafficking provisions of the Packerland Code.
That's correct, Your Honor, and the petitioner is not disputing the initial time served for the drug crime. However, for the purposes of federal sentence enhancement, the elements are not met in this case.
But doesn't Packerland define possession over a certain amount, over the minimal amounts, possession which is beyond what would be considered personal use as drug trafficking?
Yes, Your Honor,
and
but
isn't implicit in the term drug trafficking, isn't that intent?
No, Your Honor, not for the purposes of the federal sentencing guidelines. The issue here is whether Mr. Ocean's sentence is elevated under an aggravated felony or under a drug trafficking offense. Aggravated felonies apply when there is no intent in this case. Intent is required by the federal sentencing guidelines to elevate as a drug trafficking offense. Further, Your Honors, the statutory maximum in this case is 20 years, and Mr. Ocean was sentenced to 28 years, far in excess of that maximum. For these reasons, this court should reverse the 14th Circuit's holding and find that Mr. Ocean's sentence should not be elevated. Thank you.
Thank you, counsel. Ms. Gordon.
Madam Chief Justice, Your Honors, and may it please the Court. My name is Christy Gordon, and I, along with my co-counsel, Ms. McNutt, represent the respondent, the United States. I will argue that this Court should not extend Batson v. Kentucky to religious-based peremptory challenges. Ms. McNutt will argue that intent does not need to be an explicitly stated element of a state offense to constitute a drug trafficking offense. This Court should affirm the 14th Circuit and not extend Batson v. Kentucky to religious-based peremptory challenges for 3 reasons. First, religious-based peremptory challenges are necessary to create a fair and impartial jury. Second, it is...
Well, Ms. Gordon, could you explain to me why it is that we should treat discrimination on the basis of religion any differently from discrimination on the basis of race or gender for this purpose?
Yes, Your Honor. It is necessary to treat religion differently than race and gender because in JEB v. Alabama, this Court recognized that extension of the Batson challenge was necessary to gender based on the long history of discrimination in the jury selection process.
But wasn't there also a sense that this was a kind of pernicious, invidious discrimination? And would you agree that it's no less pernicious and invidious to discriminate on the basis of a person's religious affiliation and beliefs than on the basis of her gender or her race?
Your Honor, it is not invidious to use peremptory strikes on the basis of a juror's religion because a particular juror's religion and their religious beliefs may not be able to be distinguished from their religious affiliation, and thus it is very difficult for the court or the government or even the defense attorney for that matter to determine if a juror is being struck based on their religious beliefs or their religious affiliations. And because religious beliefs, members of a religious affiliation share the same religious beliefs, it is appropriate to strike a juror based solely on those religious beliefs.
I guess I'm not sure of the distinction there. I mean, it may be that certain racial groups also are disproportionately believe certain kinds of things. I mean, our belief systems are correlated with any number of things, partly with our religious affiliation, partly also with race. So I don't see that as distinguishing between the two.
Your Honor, in addition, religion is not self-evident in the same way that race and gender is. In fact, it is not always possible to determine a juror's religion based solely on their appearance. While the United States appreciates that it is certainly possible in some instances, it is not possible in the same way that race and gender is self-evident. And thus, it is not necessary to extend the Batson challenge to religious-based peremptory challenges because individuals of religious groups have not had total exclusion from the jury selection process, as did women and African Americans in this country. And thus, it is not necessary to further extend the Batson challenge.
Well, I guess I'm not sure that you answered my question. My question was, why shouldn't we see the one kind of discrimination as equally pernicious? And shouldn't we understand that both kinds of discrimination, that there will be sort of belief elements to both kinds of discrimination. And so that's another reason to treat them the same way.
Your Honor, these should be treated differently because religious beliefs go to the core of an individual's values, and thus an individual may not be able to separate their religious or moral values when deciding a case based solely on the evidence. However, that is not necessarily the case for an individual that is part of a racial or other group. And thus, because religious beliefs are core to a particular religious affiliation, it is proper to determine that based on a juror's religious affiliation, they may have a bias. In this case, the 2 jurors that were struck due to their religious activities and their religious beliefs. In this case, Attorney Catton felt that it was necessary to remove these jurors on the basis of their religious activities.
Is it your position that a religious affiliation alone cannot form the basis of a peremptory, but religious beliefs can? I mean, that's sort of a distinction that's running through the briefs in this case, and I'm not sure that that distinction has any validity here or usefulness here?
Yes, Your Honor. The United States does not distinguish between religious affiliation or religious belief. In fact, it would be much too difficult and impractical to distinguish between these definitions. And
so it's perfectly okay to use peremptories against everybody from a particular faith or denomination. No Presbyterians.
Your Honor, under the law.
Okay?
Your Honor, under the law as it is today, it would be proper to strike a juror on the basis of that affiliation. The reason for using a peremptory strike must only be gender and race neutral.
That's why we're here, counsel, right?
Yes, Your Honor.
Okay, so maybe you can answer my question.
Yes, it would be proper to strike a juror on the basis of their affiliation.
Why? Why isn't that the sort of invidious discrimination that Batson and Powell and JEB are trying to eradicate from jury selection?
Yes, Your Honor. In JEB, the court did state that stereotypes on the basis of gender were invidious. However, that is not the case for religion because individuals of a particular religious affiliation share the same religious beliefs, and thus attributing religious beliefs to a member of that religious affiliation is proper. In Cesares v. State, the Texas Court of Criminal...
Well, how far does that get us? So now we know that members of a religious affiliation share a certain set of religious beliefs. It still seems to me that discrimination on the basis of affiliation and the beliefs that affiliation might suggest seems pretty invidious. Justice Sykes said no Presbyterians, no Catholics, no Jews. Is this really the way we want our criminal justice system to work?
Your Honor, by extending the Batson challenge to other classifications, there will be no logical stopping point. And thus, because race and gender did have a long history of discrimination in the jury selection process, it was necessary to extend that remedy to gender. However, it is not necessary to further extend this protection to religion because there will be no logical stopping point, and this will create inconsistencies and impracticalities at the trial court level. If a trial court judge is forced to determine if a juror is being struck based on their religious affiliations or their religious beliefs, there may be inconsistencies.
Weren't the same issues raised on when we decided JEM? The same argument we confronted, and Batson as well, that you're terminating, you're getting rid of the whole peremptory challenge process.
Yes, Your Honor. However, by extending that protection further to religion, very few peremptory challenges will be exercised on the basis of an individual's beliefs that may create a bias. In fact, it's very difficult to distinguish between a juror's religious beliefs and their moral beliefs. And thus, an individual that holds moral beliefs that are not particularly religious would be able to be struck. However, a juror that has religious beliefs would not be able to be struck, even if those religious and moral beliefs were essentially the same. The only difference being that one had a religious backing. The Third Circuit in United States v. De Jesus stated that if a juror sees the world through a prism of religion, it would be proper to strike...
Well, think about this case. What did these two potential jurors say that suggested to the prosecutor that this was proper?
Your Honor,
what religious beliefs was the prosecutor reacting to in this case?
Your Honor, one of the jurors was an ordained minister, and thus it was reasonable to infer that based on his religious education, he may hold religious beliefs. In addition, both of these...
That just sounds like anti-religion to me.
No, Your Honor. This would simply be excluding jurors that may be more favorable to the other side. In this case, the petitioner was very religiously active in his community and was a religious leader in that community. And thus, Attorney Catton felt that it was necessary to remove any jurors that may hold a bias.
Well, but you're just saying a religious person may be more favorable to one side than another, might be more sympathetic to a religious defender, in the same way that people said a black juror may be more favorable to a black defendant, or a woman juror might be more favorable to a woman defendant. Isn't it the exact same?
No, Your Honor, this is different because religious affiliations or activities are a better predictor of a juror's bias, and thus just because an individual is of a particular race or gender does not mean that they hold particular beliefs.
Wasn't the same true in JEB?
Your Honor, yes, in JEB...
That there were studies that could correlate sex-based differences in the way jurors view cases, particularly in the area of sexual assault cases.
Yes, Your Honor. There were studies done and were used in that case. And
so the fact that it's possible to identify that sort of phenomenon doesn't ultimately answer the question that we have here.
no, Your Honor, this is not determinative. However, it is necessary to look into this issue and see that because an individual's religious beliefs are predictive of how they may how they may feel or how they may react when serving as a juror, it is appropriate to determine that religious beliefs will create a bias in some instances. And when an attorney, such as in this case, feels that an individual has religious beliefs.
My point is that the same thing was true in JEB, which extended Batson to sex-based peremptories. And it may very well be that in a sexual assault case, a prosecutor wants an all-female jury, for example, or those scenarios can be envisioned, and we still said that it's invidious discrimination and won't be tolerated, and extended Batson to that situation. So, I mean, the same philosophy of the use of peremptories applies in that context as here, so I'm not sure that distinction holds up.
Yes, Your Honor. However, the use of a peremptory challenge on the basis of a juror's religion will benefit both the prosecutor and the defendant. And thus, if a defendant has a particular religious belief or affiliation that is in contrast with the juror's religious belief or affiliation, that defendant will have the right to strike this juror. And thus, by allowing peremptory strikes on the basis of religious belief and affiliation, we are creating a more fair and impartial jury. It is necessary to weigh the defendant's right to a fair and impartial jury against the juror's right to serve on a jury. And thus, the juror does not have an explicit constitutional right saying that that juror may serve on a jury.
Is Batson intended to protect the rights of the juror or the defendant?
Your Honor, Batson is intended to protect the rights of the defendant and the juror. And thus, by weighing these two rights, it is proper to find that a fair and impartial jury is better served by eliminating jurors that may create a bias, as was the case here. The two jurors that were struck due to their heightened religious activities, and thus it was necessary, based on the petitioner's role in the community as a religious leader, to remove these jurors so that the defendant and the prosecution would have a fair and impartial jury that would not have any bias based on their religion.
I guess I'm not sure how it is that you're saying that your rule would be better for the defendant in this case. You're arguing for your own interests, aren't you?
Yes, Your Honor. However, the United States recognizes that this will also give the defendant an opportunity to strike jurors that they believe will be unfavorable to them. And thus this rule would, as is applied today, would be helpful to both the United States and the defendant.
Can you think of another area of life, Ms. Gordon, in which we prohibit discrimination on the basis of race, prohibit discrimination on the basis of gender, but allow discrimination on the basis of religion?
No, Your Honor. However, religion is protected under the First Amendment, and a juror will still have the right to freely choose their religion and practice their religion. They will simply, under this rule, not be allowed to serve on a jury if they will create a bias, and thus...
But we've understood the ability to serve on a jury as one of the hallmarks of citizenship. That's not a little insignificant thing, this disability that you're imposing on people as a result of religious belief.
Yes, Your Honor. The United States appreciates that it is an important interest that the juror has in serving on a jury. However, by bringing bias and not being able to be fair and impartial, it is in the best interest of the defendant and in creating a fair and impartial jury to remove those jurors that may create a bias.
But if they're biased, you can get them struck for cause. We're talking peremptory challenges, which is there's no bias, there's no cause.
Certainly, Your Honor. The prosecutor or the defense attorney does not have to give a reason that would rise to the level of a for-cause challenge. However, if under this rule, if a prosecutor or defense attorney has a gut feeling or instinct that a juror may be biased, it would be proper to use a peremptory strike to remove these jurors. And thus, it is not proper to delve into the juror's religious beliefs or religious affiliations during voir dire. It would be simply necessary to remove a juror if the prosecutor or the defense attorney feels that this juror may create a bias.
Well, here this factor got injected into the proceedings because it was offered as the race-neutral reason for the strike, right?
Yes, Your Honor.
So you're responsible for that, right?
Yes, Your Honor. However, this is an appropriate race and gender neutral reason for striking the jurors. And had a Batson challenge not been raised, it would have been proper to strike these jurors using peremptory strikes without giving any reason at all. For these reasons, this court should affirm the 14th Circuit. Thank you.
McNutt.
Madam Chief Justice, Your Honors, and may it please the Court. My name is Sarah McNutt, and I represent the respondent, the United States, in this matter. In my time before the Court, I will be discussing why intent does not have to be an explicitly stated element of a defendant's previous state conviction for the conviction to constitute a drug trafficking offense under federal law. This Court should affirm the 14th Circuit for 3 reasons. First, the federal sentencing guidelines do not require federal sentencing judges to evaluate only the explicitly stated elements of a defendant's state conviction to determine whether it constitutes a drug trafficking offense under Section 2L1.2. Second, the Packer-Land Controlled Substances Act is a state statutory scheme which permits an inference of intent.
Well, my understanding of this law was we look to the statute and we see what elements there are in the state statute, and we make our decision on the basis of what elements the person was convicted of. Is that not your understanding of the law?
That is, Your Honor. However, under Section 2L1.2, a drug trafficking offense is not defined only by the explicitly stated elements.
Why not?
Looking at the statutory scheme, Your Honor, Section 2L1.2 addresses several crimes, and an analysis can be instructive. Looking to a drug trafficking offense, it says that to constitute a drug trafficking offense, a defendant must have been convicted of an offense at federal or state law which has possession of a controlled substance with intent to distribute. But nowhere in the definition have the drafters of the federal sentencing guidelines imposed a strict elemental requirement.
That doesn't matter. What's important is that the predicate offense, as defined under state law, is a drug trafficking defense, which the guideline defines as being an offense that prohibits the possession of a controlled substance with intent to distribute. That's an intent element. It doesn't need to say it has an element of. It says that's what the crime has to be in order to qualify as a predicate.
Yes, Your Honor. In this case, the statutory definition in Packer-Land of the Controlled Substances Act and Mr. Ocean's previous conviction in Packer-Land are sufficient to rise to that requirement under Section 2L1.2. Mr. Ocean was convicted of possession of a controlled substance and punished specifically on the amount of a controlled substance he was in possession of.
But he was convicted under A2, and A2 clearly does not have an intent element. Isn't that correct?
Yes, Your Honor.
And indeed, the jury instructions here made very clear to the juror that they should, if they couldn't find intent, they couldn't convict under A1 and had to convict under A2.
Your Honor, jury instructions...
Is that correct?
Yes, Your Honor. Jury instructions...
Well, that seems to me to sort of end your case, doesn't it?
No, Your Honor. In this case, Mr. Ocean was convicted under A2 of the Packer-Land Controlled Substances Act, but he was also punished under Section H, which, in the Controlled Substances Act in Packer-Land, addresses possession of a specifically identified amount of a controlled substance. In this case...
Well, why should we look to H rather than A?
Your Honor, in this case, a federal sentencing judge must evaluate both to determine whether a federal sentencing enhancement on the basis of an aggravated felony or a drug trafficking offense is appropriate. An evaluation of whether or not Mr. Ocean's previous conviction warranted an 8 or 12 or 16 level sentencing enhancement must be evaluated on the basis of whether his previous conviction received criminal history points and was punishable under the Packer-Land Controlled Substances Act, addressing an element of intent. In this case, Mr. Ocean's previous Packer-Land conviction constitutes an offense that was punishable for 39 months under Packer-Land state law. Thus, federal sentencing judges must evaluate both sections H and A to determine whether or not a sentencing enhancement applies.
The jury in this case did find and was instructed, they found after being instructed on intent well, let me put it this way. They did not find intent, correct?
Yes.
It was submitted whether there was intent. What do we do with that? Do we go to the jury verdict in this case, or is it your argument that this is not a mixed case, we look at just the statutory definition? I'm not sure. How do we get around the jury verdict where the intent issue was submitted and they did not return a verdict on the intent question?
Your Honor, in this case, an analysis of the jury instructions, the jury verdict, and the indictment are not necessary. An analysis of the state statutory scheme and Mr. Ocean's previous state conviction are sufficient to determine whether or not his previous sentence constitutes an aggravated felony or a drug trafficking offense under federal law.
Yeah.
So, go ahead.
Well, I think that's right, but the statute is internally inconsistent and very hard to reconcile. The penalty enhancer doesn't fit with the base offense. And that's what's creating the difficulty here. And so we have to try to reconcile the two. Do you have a suggestion for how we do that?
Yes, Your Honor. The most consistent application of the Packerland Controlled Substances Act for purposes of federal sentencing enhancements based on drug trafficking offenses is to determine that an inference of intent is appropriate when the defendant has in fact been punished at the state level based on possession of a specific amount.
Is that as a matter of federal law or state law?
Your Honor, inferring intent based on possession of a specific amount has only been adopted in the 11th Circuit in United States versus Madeira.
That case engaged in an interpretation of the state statute.
Yes, Your Honor.
To determine whether the predicate offense counted under the 2L1.2 guideline.
Yes, Your Honor.
So the court was interpreting state law.
Yes, Your Honor.
So do we have anything that assists us from the Packerland Supreme Court in interpreting this state statute, which is so complicated?
No, Your Honor. However, looking not only at the text of the statutory scheme, but also the intent of the drafters, which is indicated in the record at page 9, the committee testimony indicates that the Packerland Controlled Substances Act was developed specifically to combat drug trafficking, not crimes of mere drug possession in Packerland. The statutory scheme is reflective of this in the fact that it addresses possession of specifically identified amounts of cocaine.
Why is someone even charged under the intent statute then when you have an amount of 100 grams of cocaine? Why would a prosecutor do that if the intent is not necessary to find a person in possession of that much cocaine guilty of drug trafficking?
Your Honor, in this case, Mr. Ocean was charged in Packerland with possession of a controlled substance and possession of a controlled substance with intent to distribute. He was subsequently punished after being found guilty of possession of a controlled substance under Section H and the statutory subsection which addresses possession of a specific amount.
Do you agree if H were not here at all and only A were here, then it would be absolutely clear that there was no intent? Is that right? For purposes of the federal statute?
Yes, Your Honor.
So your whole argument depends on our reading H as essentially trumping A. Is that right?
Yes, Your Honor.
And then in addition to that, your whole argument depends on reading into H2B an intent element that doesn't exist.
Yes, Your Honor.
That doesn't sound very good.
Your Honor, for purposes of a federal sentencing enhancement, it's necessary to evaluate the state statutory scheme in offenses such as this, drug trafficking offenses, to determine not only what the legislative intent was in drafting the state statutory scheme, but also how to apply the state statutory scheme most consistently. The Packerland Controlled Substances Act addresses two subsections which provide for possession of a specifically identified amount of a controlled substance. The lower amount identified provides for a lower penalty and includes an explicitly stated element of intent. The greater amount identified under the Packerland Controlled Substances Act, possession of between 50 and 200 grams of cocaine, not an insubstantial amount, does not include an element of intent. Thus, to determine that an inference of intent in the second subsection is not appropriate would mean that defendants subject to federal sentencing enhancements who had been sentenced in Packerland under the lower statutory subsection in sub H would receive a federal sentencing enhancement based on a drug trafficking offense. However, defendants such as Mr. Ocean, in possession of a greater amount, in this case 100 grams, would be precluded from receiving a sentence.
Ms. McNutt, I'm trying to figure out how the statute works. What if Mr. Ocean had 40 grams? What would have happened to him then?
Your Honor, Mr. Ocean still could have been charged with possession of a controlled substance or possession of a controlled substance with intent to distribute.
Right, but suppose that the jury came back, as it did here, and it only convicted under under A2 and not under A1. Then what would have happened to him for sentencing purposes?
Mr. Ocean would have been punished necessarily under the statutory subsection which addresses possession of a lesser amount, 25 and 50 grams.
But that has a specific intent element. Could he have been sentenced under H2A if he were only convicted of possession under A2?
Your Honor, it is a logical inconsistency in the statutory scheme, but looking at the state statutory scheme, it's likely that if the defendant had in fact been in possession of a lower amount, he would have either been punished only based on possession of a controlled substance and not received a sentencing enhancement under Packerland law based on possession of a specific amount because he didn't have an intent element, or he would have been punished under it regardless of the intent element being proven at trial.
What's your authority for using penalty enhancers that attach to the predicate offense to qualify a prior conviction under this guideline enhancement?
Your Honor, in United States v. Madeira and United States v. James, the 11th Circuit addressed possession of a specific amount identified under a state statutory scheme.
But that was in the statutory the statutory definition of the offense itself, not something found in a penalty enhancement, which this sort of looks like.
Yes.
In many respects, not all. So is there any authority for looking to a penalty enhancement?
No, Your Honor, not on a basis of an inference of intent for a federal sentencing enhancement. The 11th Circuit, now the 14th Circuit, are the only circuits that have permitted an inference of intent and affirmatively adopted the ruling that an inference of intent is appropriate. However... Well,
I don't read that case that way. It's not inferring as a matter of federal law that intent can be found by implication. It was just a straight-up statutory interpretation case about what the Georgia statute meant, right?
Yes, Your Honor. In that case, the defendant was convicted under the highest tier in the Georgia statutory scheme, which addressed possession of a specific amount. Although the Georgia statutory scheme is distinguishable from the Packerland Controlled Substances Act, the analysis of state statutory schemes that address possession of a specific amount is informative in determining whether or not a defendant's previous conviction is sufficient to trigger a federal sentencing enhancement of 16 levels as a drug trafficking offense.
Why shouldn't we just say that this statute is impossible to figure out, and so we should apply the rule of lenity?
Your Honor, the rule of lenity only applies in cases where the statutory ambiguity is so grievous as to justify a ruling in favor of the defendant on that basis. Looking at the federal sentencing enhancement in this case, Section 2L1 specifies that when
the problem is not in the guidelines. The federal law is not the problem. The state law is the problem.
Your Honor, in this case, the ambiguity present in either the state or federal statutes about whether or not intent must be an explicitly stated element of a defendant's previous conviction to constitute a drug trafficking offense.
Well, that's what the guideline says. So we don't have an ambiguity in the federal sentencing guidelines. There's nothing ambiguous about 2L1.2. We know that we need possession with intent to distribute. Simple possession doesn't qualify. You can see that.
Yes, Your Honor.
Okay. So the ambiguity is in the state statute. And you've just told me that there isn't any guidance from the Packerland Supreme Court about how to interpret this statute, so why wouldn't we, in those circumstances, apply the rule of lenity in the petitioner's favor?
Your Honor, in this case, the statutory ambiguity present in the Packerland statute is not sufficient to rise to the level of applying the rule of lenity.
But I thought you just told us that it was internally contradictory. There's really no way to make sense of this whole statute, is there?
Your Honor, although the statute is internally contradictory, the defendant in this case was punished based on possession of a specific amount, which falls within the highest statutory subsection, which addresses possession of a specific amount. Thus, in this case, the ambiguity is not so grave with regard to the petitioner's case.
But he was also punished under A2, which has no intent element whatsoever.
Yes, Your Honor. However, for purposes of a federal sentencing enhancement, it's necessary to look at both A and H to determine the length of the sentence and what the sentence in Packerland actually constituted. In this case, Mr. Ocean's previous conviction in Packerland is sufficient to justify a sentence of a drug trafficking offense under federal law. And for these reasons, this court should affirm the 14th Circuit. Thank you.
Thank you, counsel.
Chief Justice, Your Honors, petitioner has 3 points on rebuttal. First, restricting jury service to specific non-religious groups of people or excluding identifiable religious segments of the community, including specific religions, cannot be squared with constitutional concepts of equal protection. Second, Mr. Ocean's sentence should not be elevated because the predicate offense was simple possession and because Mr. Ocean, as determined by the jury, did not have the intent to distribute as required by the federal sentencing guidelines. And third, it is improper to elevate Mr. Ocean's sentence because of an ambiguity in the state statute. Because peremptory strikes that stereotype a juror based on religion are discriminatory, and because the jury did not find the requisite intent, this court should reverse the 14th Circuit. Thank you.
Thank you, counsel. Thank you, counsel. Case is submitted.
All rise.
So if I could have your attention just for a minute. First, before we do anything further, can we have a round of applause for what really was a terrific set of arguments? So thank you, everyone, for attending the event. Those of you who have been here in past years or who have been to a moot court competition appreciate that the judges are off deliberating. What they will do is to score the final round, and after they have done that, they will come back to the bench and they will provide comments to the competitors. While they are doing that, the moot court board will take the scores from the final round and will add them to the scores for the briefs, which these teams have submitted long ago. I'm sure it seems like a long time ago at least. And out of that will emerge a final score, and then at some point one of the moot court board members will hand Justice Kagan a slip of paper, and Justice Kagan, when she has concluded that there have been enough comments to the competitors, will announce the winners of this year's Jenkins competition.
Well, we've deliberated. Thank you all very much. You all did a terrific job. I'm going to turn it over to my colleagues first. Judge Griesbeck.
Okay, well, the first thing we did back there is I'm from Green Bay, so I felt it incumbent upon me to defend that Packerland statue. And the explanation I had is that they're too busy watching football up there to write a clear statute. But in terms of the comments on your argument and your arguments, this is different for me too, because when I hear arguments, I'm the only one there, and so I ask my questions, and it's not three judges, and so some of it, the process of answering these arguments as they're coming at you, as I went back there and tried to grade, now let's see, presentation of materials, well, none of you got through very much of your presentation before you were hit with arguments, and that's, of course, the way it is in so many courts, especially the Seventh Circuit, and certainly that's why they have argument, because they have questions. And I think what you want to do, and I think what you were very good in doing, is trying to answer those questions. And it's important that you listen to the question and try to answer the question that's asked, not the one that you've prepared or the one you want to give later. And it's frustrating because you've prepared. You've probably had this argument before, and we're not asking the right questions. We all know that. But it's really essential that you listen to the questions that are asked and try to answer those. I thought that, certainly when I gave the wrong amount of cocaine, I thought, Ms. Stromberg, you picked up, you told me I was wrong on the amount, and you told me where I got the wrong number, and that shows a familiarity with the record, and that's very helpful. The more you study that record and the cases, you want to make sure you understand the cases that really support your position or those you have to distinguish. But I'm going to talk less than my colleagues because they see a lot more arguments, and I'm more interested in hearing their comments as well as you are. But I thought all of the arguments were well done. It's a difficult issue, and part of the problem in grading is it seemed clear that on each issue, one side had an easier time of it. One especially on the extending Batson to religious claims, which seems a difficult argument. And so we try to take that into consideration as well. But I thought the arguments and the preparation was very good, and congratulations on really fine arguments. It was a difficult thing to score. Hopefully we reach some consensus.
Judge Sykes.
Thank you. First of all, let me congratulate all the competitors for a job extremely well done. This was not an easy problem. Neither of the questions were easy, and you all did a marvelous job. Congratulations to all of you. I'd like to say just a few general comments first. When you approach oral advocacy, it's very important for you to put yourselves in our shoes and think about how we will be coming to this case. We've read the briefs. We're coming to court to talk to the attorneys about the legal premises of your argument and to test the limits of your argument. And we're going to do that with hypotheticals, and we're going to ask you to think outside the box and go beyond what was in the briefs. So you have to spend time in advance of argument doing that kind of big picture thinking. You've been living with this case for a long time. You know the record extremely well. You've read all the cases. You know the law really well. What you have to do is put yourself in the court's shoes, in the judge's shoes. We have to fit this case into the broader spectrum of the law. What happens if we extend Batson? What happens if we don't extend Batson? What really is the theoretical foundation for the Batson rule in the first place? And does it apply here? Does it not apply here? You really need to do that big picture judicial thinking, because that's how we're going to come to the case and approach it. We need to fit your case into the broader spectrum of the law, so you've got to do that thinking in advance. And some issues are bigger than others. With respect to the Batson case, that's a huge constitutional issue, and what the court might do with it has tremendous consequences for the law. The sentencing guideline issue, not so much. It's a bread and butter sentencing issue, but because of the fact pattern that you were given and that crazy Packerland statute, the judicial instinct is to do no damage, right? And so you have to kind of get outside of your own case and the end result that you're trying to get for your client, and think about how the court is going to be coming to the issue, and that will go a long way toward getting you to be prepared for the kinds of questions that you're going to get from the bench. And then when you get those out of the box questions, you will have an answer for them if you've engaged in that pre-argument preparation of thinking about the case as the judge would think about the case. I have a couple of other general comments about good oral advocacy and things that really kind of get my goat when I'm listening to arguments in real court, and that is argument spin, first of all, when lawyers overreach on the law or overspin the facts. That's when you will lose credibility really fast. So if you are advocating for a legal interpretation that just goes too far, you're going to lose credibility with the court. You've got to try to position your argument sort of within the to use another football analogy, within the 40-yard lines of the mainstream trajectory of the law. And then if attorneys overspin their facts, they will lose credibility right away as well with the court, or at least with me. I should speak for myself, with me. None of you fell into those traps. So congratulations on that. I mean, you didn't fall into any of those, any of my pet peeves on oral argument mistakes. So you did a terrific job as far as that's concerned. And one of the criticisms I would have of the arguments that we heard today, and please take this in the generous spirit in which it is intended, is that we heard an awful lot of stock responses today. As though, as Judge Griesbach mentioned, you were answering a different question that was asked. It was sort of a programmed response, and I know you've been living with this problem for a really long time, and you've argued on brief and you've argued off brief, and I don't know if you were arguing on brief or off brief today. On or off? We were off brief. You were off brief, okay. And so your instinct is to sort of open that file drawer in your head and, you know, kick out what's in there in response, even if it's not totally responsive, because you want to keep talking. What you really have to do is zero in on what the judge is asking, and focus on that question. Otherwise, you're gonna get some frustration from the bench. You know, it's really important to listen very hard to the question that's being asked and try to figure out what the subtext there is, and that's a tall order for oral advocates, and you'll get better at that as you do more of this. You'll get more relaxed, and so you won't go to that rote answer that you've memorized or that file drawer in your head where you know the answer is. You'll be able to engage in more of a conversation with the court, and that's what makes for an excellent oral argument, is when you're really in a conversation with the court about the premises of your legal argument, the limits of your legal argument, and where the law ought or ought not go, depending upon the position that you're arguing in the case. So those would be my general comments. Justice Kate?
Well, first off, you did really quite well, and congratulations to all of you. I know this is a long haul when you do this in law school, and you should feel really proud to have gotten this far and to be the 4 people sitting at that table and to have done as well as you did. So congratulations to you. I think my comments are very much of a piece with my 2 colleagues. The absolute best oral advocates, and I'm really lucky because we see some wonderful, wonderful lawyers at the Supreme Court. The absolute best ones go into oral argument, I think, thinking of it as an opportunity to have a conversation with the justices. When I was Solicitor General and I first stood at the podium, the thing that's most striking about arguing at the Supreme Court is you feel as though you could literally put your hand out, and if they put their hand out, you would touch. It's that intimate, it's that close. And that encourages a certain kind of oral argument, a real conversation. And I think even in a somewhat more, there's more distance here than there is in the courtroom that I work at. The idea is to have a real conversation with the justices, and that means listening incredibly hard. And that's really hard to do because you're nervous and your heart is beating fast, and the easiest thing is to just go to the things that you've said 1,000 times before. The harder thing to do is, like, I'm really listening and I'm geared into what they're asking me, and I'm going to adjust my responses depending on what's coming at me. But I think that the worst thing you can do, the thing that makes people sort of like most distressed, is if they feel you're not answering their questions. I just asked you a question. I thought it was a good question. Maybe you don't think it's a good question. Maybe you're right. Maybe it's a terrible question. Maybe it's a question that reflects that, I don't know as much as you do. Still, it's my question. And if I don't feel like you're engaging with it, I'm just going to feel a little bit like, who are you, So the first thing is you just have to listen and have to at least start by answering the question. Now, I say at least start because I think the best oral advocates, they figure out how to make their points too. I mean, the great trick of the thing is to figure out how to do these pivots between answering your questions and making your points, and answering your questions and making your points, and always feeling, not leaving the judges in any way that they think you didn't answer my question, but also getting in the points you want to make. Now, to know the points you want to make, what Judge Sykes said is really true, that you have to come in with a kind of theory of your case, a kind of understanding of your case. And that's true of the big picture constitutional law question here, in the way Judge Sykes suggested. It's true in a different sort of way of the statutory question. I mean, the statute is a mess, right? But we're all going to approach it as, God, the statute is a mess. How do we make sense of it? Well, you have to have made sense of it before, and you have to have a theory of this statute and come in and figure out how to use your 15 minutes to sell us on your theory of this statute and why that theory is correct. And to answer our questions, but to try to pivot as much as you can into what your theory of the case is. And that's what the best people do, is always leave people as though they're engaging, they're responsive, they totally get what you're saying, but they also find ways of making clear what their theory of the case is. People used to say, I never saw him. People used to say that the Chief Justice was the greatest oral advocate of his generation. And when you ask him how he prepared for a case, this is what he would tell you. He would say, I put everything, this is sort of lore in the SG's office. You would say, how do you prepare for a case? They would say, well, you should do it John Roberts' way. Now, it turns out lots of people have tried to prepare like this, and nobody quite ever did it as well as he did. So, who knows if it's preparation. But this is what he used to do. He would put arguments of his on index cards. And then he would practice by picking up an index card and moving to any argument on any other index card. And the idea was that he would be so supple with the arguments that he would be able to get from one thing to any other thing, like that, totally natural seeming. And people said that that was what made him such an amazing Chief Justice, that it didn't matter where he was in the argument, he would always get back in a completely natural way to wherever else he wanted to be in the argument. And I think that that's what the great advocates do, is be incredibly responsive, but always figure out a way to get those responses to add up to something, and that something is your theory of the thing, your sense of the case, what you want to leave the court with. So that's a tall order, I mean, that's a really hard thing to do. And you get better over time. When I became Solicitor General, I had never done an appellate argument before, and each month I did another one, and each month I felt, okay, that was a little bit better, that was a little bit better. And that's what will happen, is that will happen to each of you. You all four have terrific talents, and you're all four going to go great, great places. And you will all learn every time that you do this, and you'll all be absolutely terrific. So thank you very much. Okay, and now I'm supposed to turn it over to the dean. Oh, I haven't. Somebody has to win this thing. I forgot about that part of the proceedings. Christina Gordon and Sarah McNutt. Now I can turn it over to the dean. Is that right, Dean?
Absolutely.
Am I not forgetting anything else?
No.
Okay.
So, 4 things. First, thank you to Justice Kagan and Judge Sykes and Judge Griesbach, this has been a marvelous evening for all of us, and while I will hold forth almost equally briefly in the forum on this, your participation in this event has really been magnificent. Thank you. Second, congratulations again to all four of the women who did such a tremendous job tonight. You really did marvelously, and as Justice Kagan said in concluding her remarks, you will go on and do terrific things in the profession. So we will recognize you as well out there. Third, for everyone here, please join us in the Zilber Forum, where we will have a reception. There is food. There are other refreshments. We will have a brief program in which we announce the winners of the Best Oral Advocate and Best Brief in the competition. So please do join us out there. And fourth, if the three judges, as everyone else is leaving, and the four competitors could sort of gather around, we will do various photographs, and then we will join everyone else out in the forum. Thank you.